A very good time of the day, dear colleagues, and welcome back to our Interviews with Institutions series. The purpose of this series is to introduce our viewers to the leading arbitral institutions in the world and to shed some light on their practices and unique advantages. Today, I have the pleasure to welcome Dr. Alice Frimoth-Wolf, the Secretary General of the Vienna International Arbitration Center. Good morning, Alice. How are you?
Hello, good morning, Elia. Thank you very much for this great opportunity and a very warm welcome from sunny Vienna. Just a week ago, we would have all met in the course of the Wismut in normal situations. And I think I really felt particularly sad because that is always the time when Vienna is most bustling. And for the second time in 2 years, we have only had the pleasure of following the Wismut in an online version. So I'm dying and hoping that next year we will all be able to meet again. Yeah.
I share your hopes, Alice. I understand that VIAC has been established almost half a century ago. Please, can you tell us more about how the institutional practices evolved over these years?
Yes, with pleasure. Well, VIAC actually celebrated its 45th birthday in 2020. It was established in 1975 by the Austrian Federal Economic Chamber. So we are basically working under the auspices of the chamber, but still are being independent, completely independent in conducting the administration of our cases. The reason why we had been established back then was the need for a neutral arbitration institution in a neutral country such as Austria, because as we all sort of remember, the Cold War and the unfortunate times back then, and there was a need for an institution that could handle and balance to administer disputes that arose between East and West trade. And I think we have since then sticked with this mission basically, and of course fortunately there is no Cold War, and the Iron Curtain has fallen, and things have developed, but still our central role in this area has maintained, and that is why also this is still our focus, and we can see it in the number of cases and the rights of parties in that area, that still people have a lot of trust when it comes to solving disputes with an international angle that involve parties from the CIS region.
Okay, that's very interesting, Alice. You mentioned neutrality, and neutrality is perceived to be one of the core elements of international arbitration. And the second one is flexibility. However, many parties fear international arbitration under the auspices of a foreign institution, believing that they would have to travel to the institution's location. I would appreciate if you help me dispel the parties' misconceptions by sharing VIAC's experiences of administering disputes with foreign parties and whether it is necessary under the VIAC's rules to come to Vienna to arbitrate their dispute.
Of course. Well, there are a lot of misconceptions and myths out there in the arbitration world, especially when it comes to the topic of place of arbitration, seat of arbitration, and also in terms of hearings. So, sort of let's put that right from the beginning. I think we first have to differentiate between the seat of an arbitration, which is really a legal concept, and the parties have to be very careful when choosing it. And the seat of the arbitration does not necessarily have to be the same as the seat of the arbitral institution. Very often it is though chosen because an arbitration institution might be located in a country where the arbitration law is sound, where the judicial practice is arbitration friendly, but these are actually the factors that need to be considered when choosing the place of arbitration, because the courts of the seat will actually be the ones deciding on the setting aside of the award, and also the lex arbitri will be decisive in terms of mandatory provisions. And while in the case of VIAC being located in Vienna and Austria, we do in fact have more than 85% of the cases having the seat of arbitration in Austria, in Vienna, this is by no means mandatory. The parties are completely free to agree on the place of arbitration and actually should bear in mind also the legal implications. The other thing is what you mentioned before is where do the actual hearings take place? And also, again, it's a myth that the hearing has to take place actually at the seat of the arbitration, because all the arbitration rules that I'm aware of even have a provision stating that hearings can take place at anywhere at the party's convenience. So the reason why very often the parties with pleasure or with joy come to the arbitration institution, and in our case to VIAC in Vienna, is because they offer hearing facilities at quite low costs. So they take away from the parties and the arbitrators all the logistical efforts for renting a place, for securing catering and translators, court reporters, and all these issues that surround the hearing. And especially for smaller arbitrations, when you have a sole arbitrator, not a tribunal secretary, this is one of the advantages that we have. So whereas it's by no means any obligation to do so, very often it is chosen by the parties simply for convenience reasons, because they feel safe at a particular place. And the institutions offer this sort of service package. And now our rooms have been equipped due to the pandemic also with special equipment to even care for sort of remote or semi-remote hearings that have become quite a standard during the pandemic, and also to assist arbitrators who do not have these facilities at their place.
Thank you, Alice. This is very insightful and helpful to our viewers to understand the seat venue conundrum. But since you mentioned seat and Vienna as a seat, what can you tell us about Vienna as a seat? Is it a safe one? Why would the parties choose Vienna as a seat of their arbitration?
Well, first of all, if it hadn't been for the pandemic, one of my first reasons would simply be to say, well, Vienna is a great city, and you have very nice side effects when you are in Vienna, and it's easy to travel and come to Vienna. But that left aside, I think what is more important is that, as I mentioned before, the legal system in Austria, we are a model law country with a very long tradition in arbitration. We have a one-stop shop with the Austrian Supreme Court being the first and only instance in setting aside proceedings and also challenge of arbitrator proceedings, where you get the decision within less than a year, sometimes even 3 to 6 months. And there's a special division within the Supreme Court who is dealing only with arbitration-related cases since the reform in 2014. And I think that's the issues that the parties really should have in mind, besides the other amenities that a particular city brings for the parties, and once traveling is again allowed.
That's really good to know. And my further question on that front would be, and what is the language of the proceedings before the Supreme Court? Because I know some countries are considering allowing English language to be used in set-aside or enforcement proceedings. What about Austria?
Well, we are not yet there, but I'm confident that it will come in the future. I know that there are discussions ongoing also concerning the commercial court, but I think this is a process, and of course we are pushing for that, and I think that would be a great development. Let's see. But for the time being, it is in German, the Supreme Court proceedings.
I see. Thank you, Alice. And now going back to the venue issue. I understand that most of the hearings during the pandemic went online. Am I right? And just a follow-up question, how did the Corona crisis affect the overall administration process?
Well, of course, we were all struck and hit by the pandemic, without any warning, which is always the case for these kind of situations. But I have to say that all the institutions, including the VIAC, have reacted extremely well in continuing to handle the cases. We know that for a lot of jurisdiction, including Austria, the state court proceedings, they had been stayed, times were being suspended. That was never the case for arbitration proceedings, at least in Austria under the VIAC rules, because we have always been quite advanced with our case management system. And we have adopted some time ago an electronic case management system that allows our case managers and legal counsels to work from wherever they are via their mobile device, and also administer the proceedings from home in the home office. Because as everyone else, we were moved to home office, but within a day we had been equipped with all that we needed, so the administration of cases worked smoothly. Then there were some other issues that we needed to tackle, is how to handle statement of claims, how to issue awards and all that. So we encourage the parties that for the time being, they should refrain from sending us hard copies, and only if that is really needed or required, we ask them to do that, because of course, when you get submitted a statement of claim and you need to forward it to the respondent, you really want some proof of service in order to establish that the counterpart, the respondent, has actually received the statement of claim. And then, of course, we did a lot of counseling within arbitration institutions to establish best practices. You probably remember this joint statement by the arbitration institutions, and we were really very supportive to each other in order to make things going and in order to ensure access to justice and continued proceedings. So even when it came to issuing the awards, we amended our Article 36 in that respect, that we said if the parties so agree, we can also send only an electronic copy of the arbitral awards, because there were times when even the postal services were not really working. And then, of course, there were some on-the-spot issues that needed to be decided, because as we mentioned before, a lot of hearings were then being conducted remotely, and not always all parties were in agreement. And you probably remember this sort of famous Austrian Supreme Court case that was one of the first ones and resulted out of a VIAC arbitration proceedings where the arbitral tribunal was being challenged because they made a remote hearing against the will of one of the parties, and then they were being challenged for not being impartial or independent. And the Supreme Court really set the scene, and I think made a high benchmark also for other countries in clarifying that the mere conduct of hearings remotely is by no means an infringement of the right to be heard, but of course, it could be if one of the parties cannot access the hearing room and so on and so on. But the mere claim that the remote hearing is infringing sort of the right to be heard, sort of that was being done with. And also in that respect, of course, we had a lot of work to do, because all these issues that came up had to be resolved. And also, just as a final sentence, that was one of the advantages of this one-stop shop system that I mentioned before, because that decision was rendered by the Supreme Court within 2 or 3 months. And I think that was tremendously valuable for the all arbitration community worldwide.
Absolutely agree, Alice. And this is very interesting insight, both from institutional side and the court side. And my next question would have been, were the parties and arbitrators understanding of VIAC's practices and how the arbitral proceedings should be conducted during the pandemic? Because I know that there are some arbitrators, very senior ones, who prefer nonetheless hard copy submissions.
We didn't really face any problems insofar the parties and the arbitrators were quite understanding in the way that we sort of changed the administration. To the contrary, when it came to the remote hearings, of course, you had different opinions. And I think it was really up then to the arbitral tribunals. And in that respect, we're very fortunate to have excellent arbitrators working under the VIAC rules who had to simply deal and tackle these issues. And of course, we were there for the arbitrators in these situations to really act as a sparing partners. I mean, we can't take the weight of the decision from their shoulders, but we can do some sparing exercises. And we really tried to remind the parties, councils, and the arbitrators that COVID-19 should not be understood as a free rider for indefinite postponement or adjournment or even suspension of proceedings. Of course, sometimes extension of time limits were necessary, but we really tried to let the parties and the arbitrators know that we want the proceedings to continue.
Thank you, Alice. I reckon the pandemic was sort of a litmus test of how the arbitral institution efficient. So
yeah.
Did the pandemic in any event affect the disputes numbers or the arbitration cases numbers?
Well, I think that you have on the one side those arbitration institutions who said that they had a record year last year, and then there are others, and I think it's that is also and it really depends on the market that you're active in, that saw a decline in numbers, but seeing an uprise in numbers this year, and that was the case for VIAC. I had the feeling that during this sort of first lockdown and all that, here people were in a kind of shock situation, also due to a lot of jurisdictions in our environment that passed laws that suspended limitation periods and made it easier for parties not having to sue immediately, but really could rely on these sort of laws that prolonged them for certain time periods. But now this time is over, and now we see these claims. And in other jurisdictions, probably it was different. So yeah, there was a kind of standstill between, I would say, March and the summer, and then numbers picked up, and this year, in the beginning of this year, we saw a real rise in numbers.
That's really interesting. And to understand the statistics better, what types of disputes are commonly referred to VIAC?
Well, as I explained before, the VIAC is not focused on a particular type of disputes, but rather on a particular region. So what we see is, and all the statistics since 2011 are displayed on our website, because we really want to have sort of this transparent approach, so everyone can see not only the nature of disputes, but also the parties and the arbitrators, and we think that's also an important service. So in 2020, for example, a third of the disputes stemmed out of commercial contracts, 26% out of ownership contracts, 13% out of retail, 7% out of construction and manufacturing, and there was a real decline in so-called M&A disputes, and the rest was being decided between transport and storage, technology, and intellectual property disputes. So it's a complete mix. Of course, usually the commercial contracts, that is the biggest share.
I see. So there is a wide variety of disputes as far as the subject matter is concerned. But what about nationality of the parties?
Well, we had in general, when we always look at it from Western Europe, CIS countries, and Austria. So in 2019 we had, or 20, we had about 43% of the parties coming from the CIS region, while traditionally it has always been around a third. So we really see a rise of the parties from the CIS region in particular, and we have usually a sound of about a third of the parties stemming from Austria. The reason why we don't have more Austrian parties, because that could be a question since we are an Austrian institution, is that only until 2018 we got the permission to administer purely domestic disputes, because this competence had been vested with the regional economic chambers and their arbitration institutions, who handed over this competence to VIAC in 2018. So it's not that common in Austria to have arbitration on a domestic dispute level, and we're really working on that. So this is why a lot of parties, I think it's, or a lot of cases don't even involve any Austrian party in our dispute practice.
Thank you, Alice. Now that you mentioned permissions, I know that VIAC is the only Europe-based arbitral center that was registered as a permanent arbitral institution in Russia. What is your vision statement on Russia and CIS arbitral markets?
Well, maybe sort of to take a step back, when we decided to apply for admission in Russia, we on the one side wanted to ensure legal certainty and enforceability of VIAC awards in Russia for the parties now and also in the future, and also to increase the choice for Russian parties to also have a foreign arbitration institution that they can trust to administer their disputes. So Russia and the CIS region have traditionally been a very important trading partner for the Austrian economy, and also the close economic cooperation is particularly important to my for me for also restoring the trust between Russia and the EU. I mean, to this end, Austria and Russia, who have a very long common tradition, have established also an important platform in the form of the so-called Sochi dialogue, which covers topics such as science, education, arts, sports, and enables a common basis for talks. So for me, actually, Russia and the CIS countries, they are part of Europe. We are all Europe, and we are closely connected culturally, economically, and in all possible other respects. And for me, it is important to stay in touch and to keep up the dialogue and think together about the futures and the issues we have to tackle. The most important ones at the moment, pressing question, climate change, and the tackling of the pandemic. So while Austria has always played a central role in exactly doing this, keeping doors open and trying to facilitate communication and the amicable resolution of disputes, VIAC's status probably has added to this mission in that it wants to enhance the trade and provide trust to the parties that their disputes that inevitably arise when you engage in trade are being dealt with diligently and without prejudice in a neutral forum, because we consider the right to access to justice as a human right that really needs to be protected.
Thank you, Alice. Just to recap, so VIAC is not just an arbitral institution. It is the think tank that aims to facilitate trade through efficient dispute resolution. And that being said, what are the key advantages of arbitrating under the VIAC rules?
Well, first of all, I think one of the advantages of the VIAC rules and in general administration by VIAC is that it's very hands-on and flexible. So we always have thought that party autonomy is key. So our rules really tried to limit it to those rules that are being considered key for the parties to really conduct the proceedings. So there is no full-fledged sort of terms of references or other issues that might be good for large cases, but for smaller cases, and we have to remember not all our cases are, $100 million cases. We have much smaller cases as well who do not need all these sophisticated issues. So in that, it gives the parties and also the arbitrators the absolute flexibility to really tailor how the dispute is being dealt with according to the needs of the parties. Should there be a hearing? Should there be no hearing? Do we really need a case management conference, or is everything that clear that a PO1 would also suffice? So it's very much up to the arbitrators with the parties to decide on these issues. Another advantage is also that we have consciously decided against emergency arbitrator provisions, because we are not convinced 100% that this is always a cure to the problems being sought. While in some cases, definitely it can be of an advantage, I think it's also good to have institutions who deliberately have chosen not to have it. So also to give the parties the choice. Do they want to be exposed also to emergency arbitrator decisions, or will they rather resort to state courts if they really need an enforceable interim injunction? we also have the expedited arbitration proceedings as an opt-in solution. So nobody is forced just by the value of the dispute to end up in an accelerated proceedings when for his or her particular case, they would consider that it's not really helpful. So we really give the parties the choice on that. And probably the third or the last issue I wanted to mention is our quite broad joinder of third party provision, which really gives the arbitration tribunal the flexibility to not only sort of get third party into proceedings, provided, of course, the arbitration agreement is being binding on the parties and the will of the parties in that respect as a true party, but also in other forms, from amicus curiae to an intervention to whatever the parties actually deem necessary in order for the process to be helpful, because that is also part of this sort of Germanic tradition, where also these other forms of intervention are being possible, and we wanted to ensure that this is possible with the rules.
Thank you so much, Alice, for your very insightful interview and answers to the questions. And to conclude, I would like to invite our viewers to visit VIAC's website and to follow VIAC on social media to stay in touch with this leading arbitral institution in Europe and beyond. Thank you so much.
Thank you very much. It was a pleasure for me.